Are you ready to argue the defense's position on Dr. Mackless being able to testify that that witness said when Mr. Jonchuck was 12, so not guilty by reason of insanity, whatever the exact quote was?
Yes, Your Honor.
Okay. So I've reviewed all this defense case law rather quickly, and I don't really think I have to review it any more than that. My position is it's certainly not a prior bad offense. His statement that if he ever committed a crime, that's not necessarily. I mean, it's not. I mean, it's not an offense. It's not a bad act. So it clearly isn't Williams' rule, and I've said before that NGRI, it has different rules than Williams' rule. It was made not that long ago. It's made at the same time the defense is getting in all sorts of other statements that he made to everyone, and even the prior bad act with the mother. At first I was going to let that in, and I agreed with you, that was tenuous. But in my mind, this would clearly come in. I can't imagine why I wouldn't. So is there any additional argument?
Judge, yes.
Okay.
So the issue is, first, that would be tantamount to a prior bad act, that statement. And so the state has to either provide notice or allege that we have somehow opened the door to it. Opening the door does not occur just by raising a defense. So under the state is allowed to use similar fact evidence of other crimes, wrongs, or acts when it's relevant to prove a material fact and issue, including but not limited to, so I can see that they're not limited to, and sanity could fit in there, but motive, intent, absence of mistake, or accident. However, it is inadmissible when the evidence is relevant only to prove bad character or propensity. In this situation, how do we know that the state is introducing the evidence to show only bad character or propensity? They're introducing it to show that he is acting in conformity with raising that defense now. It is not relevant at all except to say he previously stated on another occasion if he were in trouble that he would claim insanity, and therefore that is what he's doing now. That is the definition of them arguing that he is acting in conformity with that. Even if the court were to find that it's not being offered to show the bad character or propensity, which I submit it is, otherwise it's not relevant. They're saying he said this before and this is what he's doing. Then it would still have to be strikingly similar and share some unique characteristic or combination or characteristics which set them apart from other offenses. And so looking at Billy v. State, that's at 863 Southern 2nd, 323, Florida DCA case from 2003. In that case, this is a situation where the defendant was in a fight with the mother of his children. He ultimately took her car over the course of the night and drove her car into a canal. There were their 2 children in the back seat of the car. It was not in dispute that the defendant, Billy, in the case, took the car, that he drove her car into the canal. The only issue in dispute was he had raised the defense saying he didn't know the kids were in the car. And so the court allowed, and the state actually did file a notice of Williams rule in that case. The state has not filed any such notice in this case. However, the state in that case did file notice of Williams rule, including they wanted to introduce Billy's violent tendencies towards the mother of the children, including previous threats to injure or kill, previous instances of hitting, slapping, and kicking, a prior aggravated battery when she was pregnant, and threats and or takings of Mr. Tiger's vehicle without her consent. There was also a threat to one of the victims in November of 1994. And there were also threats in 1994 and 1995 that he had made, that he was going to kill himself and some children that he had fathered from a previous relationship. There was then some other random comment that once the mother of the kid, her mother, got custody, he, I guess, beat her up and then had made a statement that she got what she deserved. The trial court let all of it in. They ended up testifying that the defendant was abusive and violent towards her when she drank, that there were several specific instances of abuse. There was one incident that they referred to as the hammer incident that I'll go back to. The defense, in their case, elicited testimony regarding the defendant and his relationship with his children, specifically the victims in the case, the deceased children. They indicated that he saw his children regularly and that he taught them about Indian culture. In response to that, the state then elicited testimony relating to the abusive relationship with his ex-wife and introduced evidence that he had previously slapped those other children. The state argued that he had opened the door to the line of impeachment by suggesting that he was a good father. The court held that this was error. All of these statements coming in were error with the exception of the hammer incident. The hammer incident was one incident in that he had gotten into a fight with the deceased victims, their mother. There was an argument as to whether the kids were around people that they weren't allowed to be around, and he had raised a hammer in a threatening manner in front of the kids, and so the court had held that that because he had specifically threatened one of the victims, that was why that was admissible. So they said the court goes on to say that where the evidence is submitted to show defendant's propensity towards commission or to show his bad character with nothing more specifically regarding the statements that he had made. The only issue, the court held that the only issue at trial was whether he knew the kids were in the car. And so specifically, if he were to say that he didn't have the capacity for inflicting harm on his children, then the hammer incident could potentially come in. They said that everything else showed nothing more than the defendant's bad temper and his controlling personality and his relationships with women. Evidence of bad temperament towards his girlfriend is irrelevant to the issue of whether he knew his kids were in the back of the car. They showed that the evidence, they agreed that the evidence would show that he is capable of sinking his Tahoe in order to exert control over his girlfriend. However, that wasn't the issue in dispute, was not whether he was capable of sinking the Tahoe. It was the only issue was whether he knew the kids were back there. And they specifically addressed the statement that one of the things that they had introduced under Williams' rule was he had previously had thoughts that he wanted to kill himself and his other children during a custody dispute with the children. That is very, very similar to our statement, if I ever get in trouble, I'm going to claim insanity. The state sought to introduce it to show that he had intent to harm the children in the instant case because he had thought about killing his other children on a prior occasion. The court said that that does not meet the strict Williams rule criteria, that the collateral evidence has to be strikingly similar. They said that the statement was made under a much different scenario and that the statement occurred 3 to 4 years prior to the charged offense, serves no purpose except to bolster the state's propensity case against the defendant. And that is exactly what we have here. The statements aren't made in similar circumstances. In fact, Melody Dishman testified that the statement occurred when they were kids. She said maybe 12 years old, when they were out smoking marijuana, just joking around one day. Mr. Jonchuck had no involvement with the criminal justice system obviously any knowledge about the insanity defense as a legal defense at the time, had no children, had no even thoughts of probably having children at that time. So the circumstances of when it was made are completely different. He wasn't charged with a crime at the time. He wasn't able to understand any of the, court proceedings or raising defenses or anything like that. It is very similar to the situation in which a defendant says years before, I thought about killing my kids, and the state now wants to introduce that to show that he intended to kill his kids. And the court said 3 to 4 years, way too long. Here we're looking at least 12 years. And it also said because of the circumstances that the statement was made were so different, and we don't have anything more different than in this situation here. Looking at Robertson v. State, and Robertson v. State, he had the defendant was testifying, and he was charged with shooting his wife. He indicated his defense was that the gun had accidentally misfired. And in that case, then they start asking him, the defendant takes the stand, they start asking him on direct, you're familiar with large assault rifles, you purchased one before. Now the court said that line of questioning was okay because it could go specifically to whether he had familiarity with weapons and whether it actually misfired. However, then they went on to ask him during cross, and you've never threatened anyone with an AK, have you? He denied that. Then they sought to introduce prior bad acts of him threatening his wife previously, and they said that was not admissible. The state went to, you can't create an open the door situation. The defense did not open the door when the defendant in that case incorrectly answered that question, because that question was not relevant and was only being asked to try to elicit some kind of propensity or to get caught in basically a trap of propensity. And so they had allowed, after that, they introduced testimony that Robertson had threatened the wife previously with an AK-47. She testified that the defendant became enraged, pointed the AK-47 at her as she was running away, causing her to fear that she would be shot. This incident was never reported. And the court held that that statement was inadmissible Williams rule evidence. The circumstances of that and the circumstances in the instant case did not have enough strikingly similar characteristics. They do not meet the, they don't have anything unique about them to tie them that would allow it to then come in under that exception. And that one, they also talk about whether he was actually, when the prior statement was made, whether there was actually a crime that had occurred versus whether it was just a threat without a follow-through act, and how that was different from a situation where it was an actual act that he was charged with, which is, again, what we have here. In addition, does the court only want argument regarding that statement or anything else, that other bad acts? I don't know if the state intends to.
That statement.
Okay. And so I also provided the court's Johnson v. State, 408 Southern 2nd, 813. which cites the United States v. Sims, and that one indicates that's a situation where they're introducing evidence. It doesn't necessarily have to be right on the day of, but they say it has to be obviously admissible, and the court holds it 5 months before is something that could still be relevant. Again, we are talking about a situation here when there's a child out playing with his friends and makes an offhanded statement. She can't tell you the context of the conversation. It certainly wasn't in relation to Phoebe or any other living person. That it's a statement that they make as kids playing, possibly on drugs, completely randomly, to then introduce that statement 15 years later when the circumstances are not strikingly similar like it requires, and there is such a delay. It is extremely prejudicial. The courts have routinely said that it was reversible error, especially when it's a case that it obviously would be a close call. And there's just, there's no way that that statement is relevant other than the state saying that he's acting in conformity with it, which is exactly what the evidence code prohibits. Saying he said this statement and that's why he's doing this. That is the only way that it would have any relevancy, is to argue that he's acting in conformity with it.
State want to respond?
Only if I need to, Your Honor.
You don't need to. I'm going to let that one statement in because that's what we're talking about. If I were to get in trouble, I would claim insanity or whatever the exact words. It's not a prior bad act by any means. Just the statement in and of itself is really rather neutral. I mean, it's something that somebody could say at any time and mean it or not mean it. So it's not a prior bad act. This is not a Williams rule case. This is a sanity case. The jury's going to have to decide, I'm guessing, a number of things, whether or not he has a mental illness or not, whether or not, if he did have the mental illness, he needs McNaughton. And my understanding is there's at least one state witness who is going to suggest he's malingering, and I could see how one could possibly use that. I think that with cross-examination, you just pretty much neutralize its impact if you wanted to. 12 years old, he's stoned, if I ever get in trouble, I'm going to claim insanity. It's not bad character. That statement in and of itself is not bad character. It doesn't have anything to do with propensity to commit a crime. And you elicited, or almost elicited, the statement yourself when you were doing direct on Dr. Macklis. And I don't think the defense can always pick and choose what is always good or bad for their defense. And again, I repeat, him being violent with his mother twice, I did not let in, because it was definitely a prior bad act, and distinguishing between whether or not, if he did it as a result of his mental illness or not, was kind of an issue, so I didn't let it in, because I thought it could really be prejudicial. I don't think this is particularly prejudicial, and it does have some probative value, so it's coming in.
And
anything else we need to do?
So is the court holding that the statement is admissible for the state to say that he's acting in conformity with that statement?
I don't know how they're going to use it. If there's, we're not there yet. I haven't heard all the testimony.
Right, I would ask the court to proffer that, because if there is no other basis than to say that he's acting in conformity, that would violate the rules of evidence. And so I would ask the court to proffer from the state what they expect that evidence would show.
Why do I have to do that?
Because they're eliciting testimony to say that he's acting in conformity with that. That is in violation of the 404.
I'm not finding that he's acting in conformity 15 years later. I have no clue. I think it is relevant to whatever argument they want to make. I have already expressed my concerns over some future testimony. I don't know if that'll be part and parcel of that. but I don't think I have to proffer why the state is using this piece of evidence.
Okay, and I understand the court's ruling. One last point, just so the court had indicated that we have brought into the issue his insanity. We have raised the defense of insanity. That is very different from eliciting a specific character trait of a defendant. Character and personality and insanity are two different things. That is not blurred, and so just so the court's aware, we have not opened the door to any specific character trait. We have not said that he has, that he would never hurt anybody, that he is not violent, that he has never used drugs. So we have been very clear to not get into any character traits or personality. Our defense is solely that at the time of offense he was insane. Whether somebody is insane and whether their personality and character traits, those are two completely different things under the law.
Well, I think there may be some mingling in this case, I don't know, but you tell me why a statement from a 12-year-old who is stoned talking to his friend, if I were to get in trouble, I would claim insanity, why that would be bad character or a negative personality trait. I don't think it is.
Because that's what Bozeman holds. Bozeman says that. In that case, the defendant said he had thought about hurting other children during a custody dispute. And the state introduced it to try to show on this occasion he knew his kids were in the back of the car when he sunk it. It's the exact same thing. Mr. Jonchuck saying, if I ever get in trouble hypothetically, I will use this defense 14 years removed is not strikingly similar as required for it to come in as I've actually killed my daughter and now I'm going to raise this legal defense in front of a jury trial. And they specifically talk about also how the time issue, and they said that one, the 3 to 4 years, took it outside the realm of being relevant, which is what we have, and here we have 3 times that. So Bozeman says that.
Not guilty by reason of insanity is a different animal than a Williams rule. So that'll be coming in. Anything else we need to do?
There.
Okay.
Based on that statement, I would ask the court to look at Tollefson v. State. That's at 525 Southern 2nd 957. This is a situation where the defendant had, it's a bunch of DUIs. He strangled a bunch, left a bar, hit a car, hit another car, and then hit a pedestrian. The pedestrian died. He raised the insanity defense. The state sought to introduce testimony that he had received a DUI just 1 month prior, because at the time of offense he was very belligerent. He ended up, once they finally did get him, once they were finally able to detain him, he was screaming, yelling obscenities at everybody. A police officer with a canine came on. He ended up fighting with the police canine. He had to be placed in restraints, was spitting all over the paramedics. His blood alcohol level was 0.21. He indicated he had no memory. They raised the insanity defense at trial. The state sought to introduce evidence of the DUI that he had picked up just 1 month before, where he was belligerent, outspoken, and threatening the police. And the court held that that was error. They said that the state argued that the appellate's remarks to the Georgia police that he would sue them are similar enough to his remarks to the Florida police to invalidate his claim of insanity. However, statements made 1 month prior to appellate's charged offense would not rebut the theory that appellant was legally insane at the time the charged offenses occurred, since the nature of appellate's alleged insanity was that it was fleeting in duration. Furthermore, the differences between appellate's charged crimes and appellate's prior Georgia DUI offense overshadowed the singular similarity between the two incidents. And so they held that that was error to introduce that prior DUI. And so I think that even in that situation where insanity is issued, they have a specific, and that one even a lot more similar, both DUI arrests, both regarding his behavior at the time of offense. They said 1 month before, it is not relevant to what happened that time, that specific instance.
The state is not using a prior offense to try to rebut the sanity defense they might have been able to use that with beating the mother up twice, which I didn't allow in. Same rule. Are we ready for the jury?
Yes, sir.
Okay, let's bring them in, please.
I'll step out and advise Dr. Mackles.
What?
I'll step out and advise Dr. Mackles of your order.
Okay. We're ready for cross, right, Mackles?
Yes, sir.
Yeah.
Right.
Are you doing it? When are we sworn?
No, you're not.
Re-sworn being a new day, or just reminding you still under oath?
Remind. Thank you. We all got their pads and everything? Pads?
Yeah.
Pens? Okay. Approach for a second, please.
Not bad. What's up? And of course, let's make sure those are your notepads. Jury's in the jury box and seated, John.
Good morning, ladies and gentlemen. Is everyone refreshed and relaxed? Yes. Good. And there's nothing I need to know, right? No. All right, let's put Dr. Mackles back on the stand.
Dr. Mackles. All right, sir, and just remind you, you are still under oath from the previous testimony, all right? Seat in that red chair, speaking loud and clear voice for the court.
Just raise your right hand.
Yeah.
Morning, Doctor.
Good morning.
How are you this morning?
Good.
I'd like to address some issues, some points with your testimony on Friday. The defense asked you in the very beginning of your testimony if you do death penalty mitigation work, and you do, correct?
Yes.
And you would agree that that's primarily for defense attorneys, correct?
Yes.
Actually, in every instance, that's for defense attorneys, correct?
Yes.
And basically, in that type of work, you are arguing on behalf of the defense or presenting evidence on behalf of the defense, I should say, as to why death penalty is not appropriate in that particular case, correct?
I am presenting evidence looking at mitigating factors.
Right. You also testified that you do sexual recidivism work for defense attorneys?
Yes.
Right. And again, that work is primarily for the defense, correct?
I am asked to do those evaluations by defense attorneys, yes.
And those cases are risk assessments for sex offense-related cases, correct?
Please repeat.
I want to make sure the jury understands what sexual recidivism means when you do that work for defense. Those are examinations that you are doing for the defense to determine if someone is likely to commit another act of sexual violence.
The
correct?
probability that they will commit another sexual crime.
Right. And you would agree those cases and that type of work has all been done for the defense, correct?
Yes.
You said that you've done 100 sanity evaluations, correct? That was your testimony?
Approximately, yes.
Okay. And you would agree that in those cases you were primarily retained by the defense, correct?
Primarily.
Correct. And you're being paid for your work by the defense today and Friday, correct?
I'm paid for my time.
Right. And you're being paid $175 an hour, correct?
Correct.
Right. And in this particular case, you reviewed lots of documents, right?
Yes.
But you didn't actually interview anybody, did you?
I interviewed attorney Genevieve Torres.
Okay, so you did interview someone. When did you interview Genevieve Torres?
It was approximately a week before my testimony.
So a week ago.
Correct.
And when you interviewed Genevieve Torres, you had, by the time that you interviewed her a week ago, you had already made up your mind about the defendant in this case, right?
I had offered an opinion.
Right, and you'd even gone to deposition and offered your opinion at deposition, right?
Yes.
Okay. And you didn't interview anybody else, right?
Correct.
You didn't interview the defendant's father, correct?
Correct.
Didn't interview the mother, right?
Correct.
Didn't interview the mother of Phoebe, Michelle Kerr, right?
Correct.
In this case, you didn't do any testing either, did you?
No.
You did administer a PCLR to look for psychopathy.
Objection.
Overruled.
You didn't administer a PCLR to look for psychopathy in this case, right?
Correct.
You would agree that when you're talking about the defendant's childhood and his treatment at USF, the treatment that he received at USF was primarily for a conduct disorder and behavior problems, correct?
It was for ADHD and conduct disorders.
Okay. And looking at his background, you would agree that the defendant doesn't have an intelligence problem, right?
I did not see any significant deficits in intelligence.
And as a matter of fact, he reported to you that he took honors classes when he was in school in math and language arts, right?
I believe so, yes.
And you referred to him being Baker acted. Do you recall that testimony?
Yes.
All right. Now you would agree that when he was 16 and he was Baker acted, that was when he stabbed himself in the arm, right?
Correct.
And he told you that he did that so he could get out of the house that he was living in, right?
Yes, he thought he was being abused at that time.
So that was his way to achieve a goal of getting out of the house, right?
Correct.
Okay. You looked at Dr. Arthur's records, and you testified about those on Friday. Dr. Arthur was the psychiatrist who treated the defendant from 2011 to 2013, correct?
Yes.
Okay. You would agree that most of those records from Dr. Arthur dealt with the defendant having a mood problem, or mood disorders, or mood issues.
Mood issues and symptoms of psychosis.
Symptoms of psychosis. The truth of the matter is there's actually only one reference in all of Dr. Arthur's reports to anything psychotic, correct?
No.
You disagree with that?
Yes.
The records from Dr. Arthur indicate that there was one occasion where he thought that there were some issues with his skin, and that could have
Objection,
been,
counsel testifying.
Sustained. It's cross, go ahead.
and that particular issue could have been some type of hallucination. One reported instance in which the defendant said he had what appeared could have been a hallucination. Is that accurate?
It is accurate about hallucinations, but also in the notes he talks about Mr. Jonchuck having paranoia, which can also be a delusion, which is a symptom of psychosis.
But Dr. Arthur never said psychosis anywhere in his records. He never wrote the word psychosis in his records, correct?
Correct.
He never wrote delusions anywhere in his records, correct?
Correct.
Okay. In fact, I have them right here. I can approach if you'd like to look at them. When Dr. Arthur comes to his notes and gets to hallucinations and perceptual disturbances, he actually writes none reported. That's accurate, isn't it? Would you like to see it?
I have my own copy if I can pull that.
Yes.
Please repeat your question.
Dr. Arthur's records, letter F, and again I can show you what I'm looking at if you need to see it. There's a question for hallucinations and perceptual disturbances. Dr. Arthur wrote none reported. Is that accurate?
You'll have to show me
Can I
specifically
approach
where
the
you...
witness, John?
Sure.
Correct.
Again, I'll ask it again. Hallucinations and perceptual disturbances, Dr. Arthur wrote none reported.
On that sheet, yes.
And bipolar 2 was the diagnosis that Dr. Arthur gave the defendant, right?
He gave him several diagnoses. That was one of them.
Right. And you diagnosed the defendant with bipolar 1, correct?
Correct.
Those are different, bipolar 1 and bipolar 2, right?
Correct.
Bipolar 2, you would agree, is generally associated with depression and bouts of depression, whereas bipolar 1, one of the primary features is mania. Do you agree with that?
No,
Okay, so there's no distinction between bipolar 1 and bipolar 2?
there are distinctions.
And you would not agree that the DSM talks about depression or a major episode of depression in bipolar 2?
In bipolar 2 disorder, you have to have a major depression. You can also have manic episodes, but what is particular is you have to have a major depressive episode. In bipolar 1, it's necessary to have a manic episode, which is not necessarily in a bipolar 2 disorder.
Right. And so that's why I want to make it clear to the jury, your diagnosis and Dr. Arthur's diagnoses are different, right?
Yes.
And as far as the one instance in Dr. Arthur's records that talked about a possible hallucination with the skin bubbling, or do you know what I'm referring to?
Yes.
You can't testify today that that wasn't drug related, can you?
No.
In November 2014, the defendant told you that he heard the voices getting louder. Do you recall that?
Yes.
All right. And in September of 2014, he also heard the voices getting louder, right?
That's when they initiated, he reported.
Now, he reported to you that in September of 2014, when the voices were getting louder, he noticed that when he was using drugs, that had an effect on the voices getting louder, right?
That it increased it, yes.
It increased it. What kind of drugs was he taking in September of 2014 when the voices were increased?
He reported that he was smoking spice.
And what else?
He used crystal meth a couple of times.
Now, as a doctor who's conducting your sanity evaluation, you have to eliminate drug use on the date of offense, correct?
Yes.
Because if he's on drugs when he commits the murder, then he's not insane, right?
That is what case law says, yes.
And you would agree with that, correct?
Objection, Mr. Hopper.
Counsel.
So I'd like to clear that last question up for you. So if he is on drugs when he commits the murder, and that is what is causing the psychosis, if the drugs are causing the psychosis, then he's not insane, correct?
Then I would not give that opinion.
That he is insane,
That
right?
he was insane.
And in this particular case, you're relying on the defendant telling you that he was not using drugs on the date of offense, correct?
I'm using his self-report as well as the reports of family members who observed him that month, as well as individuals who evaluated him at that time, police officers, as well as attorney and priest reports that indicated that he did not appear to be under the influence of alcohol or drugs.
And as far as mental illness goes, you agree that mental illness does not, or the presence of mental illness doesn't automatically equal insanity, right?
Correct.
There's a second prong to that, correct?
Yes.
You have to, in order to be insane, not understand the nature of your actions, the consequences, right?
Correct.
Or you don't understand the wrongfulness of your actions, correct?
Correct.
Okay. In your opinion, did Mr. Jonchuck, the defendant in this case, know what he was doing when he dropped Phoebe off the bridge?
Factually, the information that I have is that he did have that information. He did have that appreciation.
So you believe he understood that he was killing Phoebe by throwing her off the bridge?
No, for that there is mixed messages, so that because there's mixed information about that, I'm not able to give an opinion.
So you don't know if he understood the consequences or not. Is that your opinion?
Correct.
And when you interviewed him, he wasn't displaying psychotic symptoms during your interview, right?
He was not displaying hallucinations or delusions, although his thinking was disorganized and that he was very distractible. He was jumping from topic to topic, and I had to keep him on track in order to get the information in which I needed.
But no delusions or hallucinations, right?
Correct. He
And
was
we're talking
being,
about psychotic symptoms.
Let him finish. Okay, thank you. You can finish now.
correct. He was being medicated at the time, and medications were addressing his hallucinations and delusions.
Now, prior to your interview with him, you're aware that the defendant had read the police reports in this case, correct?
Objection.
Overruled.
Improper.
Overruled.
I don't know exactly what information he obtained about the offense.
We'll be referring to page 57, Depo, line 16 to 25.
Yeah.
Good, Doc, you need a couple of other things?
I'm good, thank you.
So, Coach Winchester, Dr. Mackison showing you your deposition. You remember when that was taken, correct?
Yes, I do have a copy here.
Okay, this is page 57. Yeah, I'll go back and just ask you to refer to page 57, lines 14 through 17. Let me know after you've read that.
I see it.
Okay, and you would agree with me that prior to your evaluation of the defendant, he read the discovery in this case, correct?
That is what he reported to me.
All right. And I want to talk a little bit about his relationships. You would agree that the defendant had a bad relationship with his mother as he was growing up, right?
Yes.
She wasn't there for him when he needed her.
Maybe approach.
Yes.
that the defendant didn't have a good relationship with his mother, right?
Growing up.
Growing up, right?
Correct.
She wasn't there for him, correct?
Correct.
Oftentimes he would be waiting to see her and she wouldn't come and pick him up, right?
That's what was reported, yes.
That's what was reported, right? And you read that in the discovery that you were provided in this case, correct?
Yes.
Right. And you would also agree that the defendant's conflict with Phoebe's mother, Michelle Kerr, was a real conflict as well, correct?
Objection. Overruled.
Right?
Yes.
Okay. And that there were custody issues there between the defendant and Michelle Kerr over Phoebe, correct?
Yes.
You would agree that Michelle Kerr did have a new boyfriend, right?
Yes.
His name was Guy Kisser, correct?
His name was Guy Kisser. They had been together for a few months. I don't know how you describe new. It wasn't a brand new relationship. They had been together for a few months by that time.
Right. Well, new to John, I guess, is what I really wanted to point out. And you would agree that Guy Kisser is a real person, right? And that there were real issues going on between Michelle Kerr, Guy Kisser, and the defendant, correct?
Well, there were issues between Michelle and John, and there were also issues between Guy Kisser and Michelle.
Right. And yes, Friday when you testified, you referenced an email that the defendant sent to his friend Tasha Clare. Do you recall that email?
Yes.
Okay. You also testified that that was sent at 12:41 a.m. and that that's the middle of the night. Do you recall that testimony?
Yes.
Do you really believe that 12:41 a.m. is the middle of the night for a 25-year-old?
It depends upon the 25-year-old.
All right. So you would agree that in that email, which was sent on January 5th, 2 days before the murder, the defendant was not grossly psychotic in that email, correct?
No.
You don't agree with that?
No.
Have more, Your Honor?
Sure.
Do you have a copy of it?
Yes.
You may want to pull it out. Does the defendant report anything about delusions in this email?
No.
Does he report anything about hallucinations in this email?
No.
All right. In this email, he's trying to make amends with his friend Tasha, correct?
Yes.
He says he's getting his act together, right?
Yes.
He says he's not going to use drugs anymore, right?
Correct.
He apologizes for anything he's ever done to offend her, right?
Correct.
And you say this is grossly psychotic?
I'm saying in this writing itself, there are not the indications of hallucinations or delusions, but what exactly is going through his mind while he is writing this, I do not know.
Okay, so that's why you say that this is psychotic. Because, okay. So, you testified that the defendant told Reverend Caesar Patia that he asked for an exorcism.
Yes.
But you're aware that the Reverend Caesar Patia denied that, correct?
Yes.
Let's talk about Melody Dishman. You started to talk about her on Friday. Do you know who I'm referring to?
Yes.
Melody Dishman is a longtime friend of the defendant, right?
Yes.
They grew up together, going back to childhood, right?
Yes.
And they even remained friends in their adult years, right?
Yes.
Now, you relied on information that Melody Dishman provided to Detective Miller in this case, correct?
I reviewed that, yes.
Right. And that was specifically a police report that she reviewed from the St. Petersburg Police Department, right?
Correct.
And within that police report, Detective Miller had summarized an interview that he had with Melody Dishman, right?
Yes.
Now, in that police report, Melody Dishman made reference to...
Objection. Calls for hearsay.
In that police report that you relied on, you testified on Friday that there were references to demons, correct?
Yes.
And that the defendant had told Melody Dishman she's possessed by a demon, right?
Yes.
And you relied on that, correct?
That was one piece of information that I relied upon.
And you
yes.
testified to that on Friday to this jury, right?
Yes.
Within that same police report, within that same statement, Melody Dishman also made another statement, didn't she?
Yes.
Okay. And I think you were going to talk about that on Friday. You reviewed that as well, correct?
Yes.
All right. In that statement, Melody Dishman reported that the defendant told her being Melody, that if he ever got in trouble one day, that he would claim insanity. Correct?
Yes, when he was 12 years old.
Right. And he said that to her, according to her, when they were 12, right?
Correct.
But at the time that you reviewed that police report, you didn't know how old the defendant was when he said that to Melody, right?
Correct.
You didn't know the context of that, correct?
Correct.
You didn't know where they were when he made that statement at the time that you reviewed that police report, right?
Correct.
But yet you discounted that statement in your opinion without knowing the context of it, right?
No.
Did you know the context of it?
I did not know the context of it.
Did you call Melody Dishman and ask her what the context of it was?
No.
Did you do any research to try and find out what was the situation when he said that statement?
No.
But you didn't reference that in your report that you provided to the defense, did you? That statement that the defendant made to Melody Dishman, you did not reference that in your report.
I have to go through my report to see if it's in there.
Would you like to take the time to do that?
Yes. I did not see it in my report.
Right. So you cherry-picked from that interview with Detective Miller parts that were good for you and excluded a part that was bad for you, correct?
Argumentative.
Overruled.
Correct?
What I put into my report and what I used as evidence and information in expressing my opinion was information that was corroborated, information that there was extensive information about, that I could really use that information to give an opinion regarding that information. And as just was indicated, there was no context for that statement, there was no timeline for that information, and just as it came out in her deposition, this was a statement that was made at 12 years old, which to me is inconsequential in regards to the offense in which we're talking about.
But you've already testified that in your opinion, we go all the way back to 5 years old when we talk about his mental health, correct?
Yes.
So childhood is important. And what happens in childhood is important, right?
Depends, and to a degree. What's most important is the time period before, whether it be weeks, months, maybe a couple of years before. Certainly what happened in childhood is less important than what was important in one's 20s, in this case in John's 20s and moving forward.
Well, you would agree that childhood is important if you're looking at the defendant for a diagnosis of antisocial personality disorder, correct?
No.
No?
No.
A conduct disorder is required in order to have a diagnosis of antisocial personality disorder, and that conduct disorder has to begin in childhood.
Yeah, so first you would be looking at the diagnosis of conduct disorder when they're in childhood.
Right. That's my point. And that's in childhood, correct?
Correct.
All right. So what's confirmation bias?
Confirmation bias is when you go into a situation, even a forensic evaluation, you go into a situation with the result in mind, and then you look at evidence that just points to that conclusion rather than looking at all hypotheses.
On January 7th, the day before the murder, Mickey, the defendant's stepmom, reported that John seemed okay, correct?
I believe so, yes.
And his mother also said that on January 7th, the day before the murder, he seemed okay, correct?
That's what she reported.
Right.
They also reported, though, that he was obsessing about the Bible, about being possessed by demons and things like that. So there was a contradiction in what they reported in that respect, as well as the other reports.
Well, you would
which
agree.
they had.
Sorry, I thought you said. You would agree that on January 6th, that when the defendant met with Genevieve Torres, his family law attorney, that he seemed okay to her on that day, correct?
No,
On January 6th?
correct.
I'm not talking about the day of the murder, I'm talking about the day before.
I understand.
What I'm asking you is, she reported that he seemed okay to her.
She used those words, although she also talked about he was loud and he was hyper. And these would be symptoms of a bipolar type of disorder.
Well, you would agree that she said that he was goal-oriented, or she described someone who was goal-oriented, right?
Yes,
And that the way that she described his behavior that day was that he was logical in his thinking, correct?
I believe that's what she said. I'd have to look at the record.
When the defendant was evaluated by the Hillsborough County Sheriff's Office at St. Paul's Church, he was evaluated by a couple of sheriff's deputies, right?
Yes,
One was Deputy Rizzo, the other was Deputy Hallberg. Do you recall that?
yes,
Okay. You would recall that Deputy Hallberg confronted the defendant with his statement to Genevieve Torres on the 7th that she is God. You recall that?
yes,
And you'll agree that his response to Deputy Hallberg was something along the lines of, lawyers think they're God because they make all the decisions. Right?
something to that effect.
Okay. And that he also told the Hillsborough County Sheriff's Deputy that he was going to join the church and getting his life back on track. Correct?
Correct.
Now I just want to confirm, previously you had told this jury on Friday that you can't turn psychosis on and off. Is that accurate?
Correct.
With Father Swingros, the defendant made a comment that he's the Pope, but then retracted that comment. Correct?
He retracted it after the father said something like, you don't really think that you're the Pope. And then he said, no.
Correct. And you mentioned something on Friday about the elbow test, but that's not the standard of insanity in this state, correct?
Correct.
All right. So what you're referring to is more of an outdated model of sanity, correct?
Well, it's not used in the state of Florida.
Not used in the state. You don't know if his actions on the top of that bridge could have been an attempt to commit suicide by cop, do you?
There were no indications for that.
What is suicide by cop?
Where you commit a crime in front of a police officer and make some motion in order so that they will shoot you and thereby committing suicide.
That's something that could have been happening on the bridge. You don't know, do you?
Objection to speculation.
Overruled.
You can answer.
It's possible, but it doesn't go along with all the evidence that I reviewed.
And you talked about the elbow test on Friday, meaning if someone commits a crime at the elbow of a police officer, they're insane. But you would agree that people commit crimes on police officers, correct?
Yes.
All right, people flee from police officers, correct?
Yes.
Let's talk about, and I'm referring specifically to your report if you need to refer to it, the defendant's probation, okay? So on January 7th, 2015, he was on probation for reckless driving, correct?
I don't believe so.
All right. Do you want to take a look at your report?
What page?
20, at the bottom, the last paragraph.
Judge, we renew our objection to this testimony.
Yes.
Okay. And that came up on the night of January 7th when the defendant was with his father and mother the night of the murder, correct?
You all need to approach, just so I can clarify something.
The defendant tells you he has an argument with his father, right?
Yes.
And his father picks up the phone to call the police, correct?
He said he was going to call the police.
Right. And how did the defendant respond?
He unplugged the phone.
And why did he tell you he did that?
He unplugged the phone so that his father would not call the police.
Which was because he was worried about having his probation violated, correct?
Correct.
So you would agree in that moment he was aware of legal consequences, correct?
Yes.
When the defendant was at the Pinellas County Jail, he talked to Dr. Hernandez and specifically asked when he was going to be transported to Hillsborough County, correct?
Yes.
All right, and he wanted to know when he was going to be transported to Hillsborough County because he had a violation of probation for the reckless driving, right?
Yes, which seemed to be a bit of distorted thinking that he's here in Pinellas on a murder charge and he's worried about his probation in Hillsborough.
And you would agree that the violation of the probation was the murder charge. That was the basis, correct?
Yes.
All right. And you're saying it's unusual that he would be concerned about...
No. I don't know what he knew at that moment in time, what charge he thought or knew that he was under. He knew he was arrested and that was going to affect his probation in some manner.
Right, as it would, right? In any situation,
yes.
Correct? So you're telling this jury that it's unusual that he's concerned about a reckless driving charge when he's facing a murder. That's your testimony?
Yes.
But you would also agree that if he doesn't like where he's housed at the Pinellas County Jail, it's an opportunity for him to go somewhere else, right?
I would imagine so.
And you're aware that he wasn't happy about the person who was in the cell next to him at the Pinellas County Jail during this time, correct?
I believe so.
That person in the jail cell next to him was taunting him, correct?
I don't recall.
You don't remember reading that in the records, that the person in the cell next to him was keeping him up at night and shouting things to him?
I don't remember it being in the record.
You do?
I don't.
You don't. You would agree that a delusion is fixed, correct? That's what you testified to on Friday?
Yes.
And in fact, you gave the example of the FBI delusion or CIA delusion. Do you recall that?
Yes.
And if someone believes the FBI is out to get them, your testimony was you can't convince them otherwise. Is that right?
Correct.
Okay. In this particular case, you testified that the defendant was hearing voices. Is that accurate?
Yes.
And the voices told him there was an ice age, right?
That was one of the things the voices were telling him.
And that both he and Phoebe had to die in order to save the world and keep the world from going to hell. Is that right?
Correct.
But right after that, when he's on top of the bridge, he hears another voice, right? Telling him that he's God.
Yes.
And if you're God, you would agree you don't have to kill your child to save the world, right?
I don't know. I mean, it's also looking at it in a very rational way when you're talking about an individual who was thinking very irrationally at the time.
Well, but you said the delusions don't change. In this case, the delusion changed, right? Went from Ice Age, save the world, to I'm God.
Well, it didn't change. There was just additional delusions and hallucinations going on. It didn't change.
That's your opinion, right?
That's what he reported.
When you asked him why he did it in that exact moment, he didn't have an answer for you, did he?
He reported that all along he was hearing these hallucinations that both he and Phoebe had to die, that the Ice Age was coming on the bridge, that he was God. But in the exact moment that he dropped Phoebe, when I asked him what he was thinking, right at that moment he said that he did not know.
In fact, there's no record anywhere that says what he was thinking at that exact moment, right?
That is correct. I don't know how you would have a record of that.
So the delusion that you're telling this jury that caused this murder was that both he and Phoebe had to die in order to save the world, right?
And for them not to go to hell,
And
yes.
for them not to go to hell. Both he and Phoebe, correct?
Correct.
But he didn't jump, right?
Correct.
He said that he was fleeing south because of the Ice Age, right?
Yes.
But then when he got on Interstate 75, what direction did he travel?
He traveled north and then he made a U-turn and traveled south.
Well, he made the U-turn to travel south when the police turned on their lights and sirens, correct?
That was at that time.
Right. That was in response to the police turning on their lights and sirens to do a traffic stop.
I don't know if it was in response to that or why he did that U-turn at that time.
He did the U-turn right after the police turned on their lights and sirens, correct?
Objection, improper counsel testifying.
That's cross, you're right.
Overruled.
But otherwise, he was going north on Interstate 75, correct?
He started traveling north, correct.
When you asked him about fleeing from the police, he couldn't remember. That's what he told you, right?
He said
Memory's vague.
the memory was very vague. He talked about that he got blocked off and then turned around to where he dropped Phoebe.
Right. So don't you think that's convenient, that that part of his memory is somehow not there?
Objection, improper.
Overruled.
Please repeat the question.
Isn't that a little convenient, that the part of this where he's fleeing the police, somehow he doesn't remember that?
Well, the reality is that he didn't have specific memories of many of the events during that time, and some of the memories or reports that he had at the time were actually incongruent. They were not the same as the police reports at the time. So I'm not sure about the word convenient. He had difficulties with memory in regards to the whole few days that we're referencing.
But you agree that his actions after he dropped Phoebe off the bridge can be seen as evidence that he was fleeing from the police, correct?
It could be seen that way.
Right. And if you learned that when he was fleeing the police, his speeds got up to 90 miles an hour, would that change your opinion?
It would be a factor that I would take into consideration.
How so?
Well, if he was speeding away rather than acting in a calm manner, that would be some indication that maybe he was trying to escape the situation.
Now, you also reviewed the defendant's statements to Sergeant Terry Hubble, right?
Yes.
And he described things that you testified to as delusions, correct? Or hallucinations.
Terry Hubble is a female.
Yes.
and some of the things in which he talked about were very, very significantly delusions.
Right. But as he was talking to Sergeant Hubble, he never once mentioned escaping an ice age, correct?
No.
He didn't tell her that he and Phoebe had to die or the world would go to hell, correct?
Correct.
He didn't tell her that he was trying to save the world, right?
Correct. He was focused on that he was God and he needed to be taken to the city of Babylon. And he needed his Bible at that time.
But he didn't give her the explanation of why he killed Phoebe. You agree with me on that?
Correct.
Now, in the interrogation room at Manatee County Sheriff's Office, the defendant told you that he still thought the world was going to end, right?
Correct.
And we watched that video, and we see him sitting there with the hoodie over his head, right?
Correct.
And he's eating Ritz crackers, right?
Yes.
He doesn't tell anyone there that the world is about to end, correct?
Correct.
At some point, he tells you that when he's in that room, he, quote, comes to his senses and knows that Phoebe was hurt. Is that accurate?
He had that feeling, yes.
He also said to you that at some point he was hearing voices saying that Phoebe was saved by a school of dolphins. Is that right?
Yes.
So the delusion has changed again at that point, correct?
No. Again, this is an additional delusion that he's experiencing, not a changed delusion.
But he previously never mentioned anything about dolphins, right?
Not to me, no.
Have more, Your Honor?
Yes.
That's all I had, Your Honor.
Redirect.
Thank you, Judge. Morning, doctor.
Good morning.
Doctor, I have some questions that I'd like to ask you based upon some things we talked about this morning with the prosecutor. They mentioned that early in their questioning of you that John exhibited a goal when he achieved that goal. You recall that testimony or that line of questions?
No.
Let me pose a hypothetical to you, doctor. If a person, let's say this person has mental illness, and they realize they're hungry, and they drive through the McDonald's drive-through and they order food, is that goal-directed behavior?
Yes.
Is that proof that they're not mentally ill?
No.
Okay. So, mentally ill people have certain goals, and if they achieve that goal, it doesn't mean that they're not mentally ill.
Can I object to leading?
Not.
Go ahead.
I'm sorry.
Go ahead.
Not at all. As I explained the other day, a person can take care of their needs. They can be very goal-directed in many different circumstances. But just because they're goal-directed doesn't mean that their thought processes, their thinking is not psychotic, that they're not experiencing hallucinations at that time, that they're not experiencing delusions at that time. They're able to take the automatic steps in order to get certain needs met.
Doctor, we also, the state asked you questions about Dr. Arthur's report and what was not written in that report. Did Dr. Arthur ever write in his report that John was insane?
No.
Does that mean then, therefore, if he didn't write it in his report years and years ago, that John could not have been insane?
Objection, this is irrelevant.
Overruled.
No, obviously not.
They also, you reviewed a record that they showed you that indicated that at one time Dr. Arthur wrote, as far as hallucinations, none reported. Is that correct? Did you see that record?
Yes, it did.
And that was one page of those records?
Yes.
Are there other times in that record where Dr. Arthur notes hallucinations?
He notes somatic hallucinations as well as paranoia.
During the questioning this morning, they asked you that if your diagnosis differed from Dr. Arthur's. Is that-
Yeah.
Okay.
Yes.
What was Dr. Arthur's diagnosis?
He had many diagnoses. One was he diagnosed him with bipolar II disorder, was one of the diagnoses.
What was your diagnosis?
Bipolar I disorder with psychotic features,
Are both of those a mental illness?
severe mental illness.
Did you review other doctors' reports in this case besides just Dr. Arthur's?
Yes.
Did you review Dr. Otto's?
Yes.
Did you review Dr. Mayer's?
Yes.
Did you review Dr. Burston's?
Yes.
Did you review Dr. Williams from the, not me, from the state hospital?
Yes.
Did you review Dr. Hernandez from the jail?
Yes.
Did you review Dr. Lazaro's opinion?
Yes.
Did all of those opinions agree that John had a mental illness?
All except for Dr. Lazaro's.
Everybody's opinion, other than Dr. Lazaro, is that he has a mental illness.
A severe mental illness.
They asked you if it was important, in your opinion, to eliminate drug use as the cause of the psychosis, and that was one of the factors that you relied upon in forming your insanity opinion. Is that what they asked you?
Yes.
Did you review police reports in this case that explain to you whether the defendant was under the influence of drugs or alcohol?
Yes.
Can you list some of the police officers that told you, or that put in their reports that he was not under the influence of drugs and alcohol?
Well, according to police officers,
Let me ask it another way, doctor, save you some time. Did you see any police officer's report that says he was under the influence of drugs or alcohol?
no.
Did you see any report from any of John's family members that said he was under the influence of drugs or alcohol?
No.
Did you see any report or any documentation that, I guess we covered it. I'll move along. You interviewed Mr. Jonchuck as part and parcel of your forming your opinion as to his insanity.
Yes.
When you interviewed him, had he received, or was he medicated on Haldol?
Yes.
When you interviewed him, was he medicated on Seroquel?
I'm just checking my notes to be accurate. Yes.
Was he prescribed and taking gabapentin?
I believe so.
Was he prescribed and taking Wellbutrin?
Yes.
Was he prescribed and taking Cogentin?
Yes.
To your knowledge, was he taking any of those medications when he was on top of the bridge?
No.
The prosecutor asked you if, when you interviewed Mr. Jonchuck, if he had reviewed discovery.
Correct.
Are you telling the jury what you know to be true, or what Mr. Jonchuck told you?
It's what he reported to me.
Okay. You testified this morning regarding Reverend or Father Patia. And what John says he talked about with Reverend Patia.
Yes.
And they asked you about exorcism, and they asked you about whether Reverend Patia ever said that, whether he ever talked to John about exorcism. Is that correct?
Correct.
Did you review Patia's statement to the police?
Yes.
Did you review Patia's deposition?
Yes.
Did his statement to the police and his deposition corroborate that John has a mental illness?
Reverend Patia saw that John had a very severe mental illness.
Did that interview confirm that John was suffering from delusions or hallucinations regarding the devil?
He was talking a great deal about the devil.
Is it your opinion that exorcisms are to drive out the devil?
The devil or demons.
We talked this morning about a fight that John told you occurred between he and his father. I want to make sure I'm clarifying what we're talking about here. Is that when we say the word fight versus argument, is there a difference? I mean, did you get an idea whether he was talking about a physical fight or a verbal argument?
It was very specifically a verbal argument.
And John told you what happened in that.
Yes.
In your review of the police reports, did you ever see his father saying that that happened?
I don't recall.
In your review of the police reports, did you ever see his stepmother, Mickey, say that that happened?
Again, I'd have to look at the report.
Ladies and gentlemen, we need to take a restroom break, Mr. Williams. We'll go ahead and take our morning break until 5 to 11, 10:55. Thank you. You're free to do whatever.
Okay, thank you, Your Honor.
Is there anything we need to discuss?
Not from us, but
Not from you, Mr. Ellis? Are there any thoughts yet on Mr. Castle?
Sure.
Yeah, that's
Judge, we did, briefly, technically under statute it doesn't fit, but it's not a constitutional issue. I mean,
Okay.
He apparently lived here, got the, it's my understanding, and I wasn't present for all the conversation, but he just lived here, got the jury notice, then moved. It's my understanding how he moved to Pasco. But that's not a constitutional permanency that would require his removal. And if we present some cases, if we get to that point later on, I'm not ready to do that right now. I just got some emails from people back at the office giving me some.
Okay.
We've not had a chance to talk about it yet.
Okay, all right. So we'll reconvene at 4:01.
All rise. Be in recess till 5 after 11? What you said? 5 after 5 till? Till?
I think that's 5 till 11.
5 till 11.
Dang, you want to do it? That's your time limit?
Trying. Mr. Jonchuck?